having just really challenging technical difficulties in the last few days with calls dropping. So I don't want to push it. So I'm not doing video at all. Okay, gotcha. I imagine, just to warn you, I imagine at some point there will be a lot of visual aspects to testimony. So just to forewarn you. Okay, and I'll try to have the packet kind of manually in front of me as we go. Okay, perfect.
I have a copy of it as well.
So I think all the commissioners are here. They're going to be here. I just want to confirm, did all of the commissioners get all of the comments that were submitted yesterday, and then also today, and the analysis that was provided by the Friends just before, about an hour before the meeting?
I didn't get the Friends.
I have not, but this is Commissioner Willis, but I will look to see what I'm getting. It's really spotty lately. I don't know whether it's Google or what is going on, but I'll look to see what I've got.
And this is Brad Dehart. I haven't seen that, and I likely won't have a chance to get access to it during this meeting, but if it can be brought up on the screen in some fashion, that would probably be helpful.
Okay.
Commissioner Booth, I got it and I've read it.
Okay, perfect. And then Russ?
I have it. I didn't see it till you brought it up, so I'm just reading it now.
Okay. Okay, we'll probably go over that during the hearing with the whenever folks start providing testimony. We'll see if some of that information is going to be provided or if different analysis materials are going to be provided. So, and it's primarily, the analysis was provided from the Friends of the Gorge. I'm wondering if they'll kind of go off that verbatim. We'll ask them when they get into the meeting. But if not, that should be reviewed.
Okay, it's 3 o'clock. Are we ready? Everybody ready?
One quick thing. Jency's getting a long delay on her end, which will be critical for meeting minutes. Let's just give her 2 cents if that's okay.
Sure. Yeah.
Jency, really quickly, I'm getting locked out of logging into the Wasco County website.
She can't hear you. Message her.
I don't know. Everything is like repeating and repeating and repeating. So everything's talking over itself. So I'm not sure what's going on, but I can't really hear what anybody's saying because it's just jumbled.
Do you have the live stream open on a separate page, maybe like the YouTube open on a separate page?
So as long as we record this, it says we're live on YouTube. As long as we record this, it's coming in clear on my end. We should be able to do minutes, verify the minutes after the meeting, but I don't see that it's being recorded yet. Do you want me to click record? I don't think you can hear me. I'm just going to do it. And Kelly, I'm recording to the cloud just so that you know where it's going. Okay. No, oh, she's telling me not to do that.
I need it recorded locally.
If I record on my computer, is that okay?
I'll record, but then I'm going to mute and somebody else maybe can do.
Yep, we got you. Okay.
This is nothing.
Okay, Chair, I will message directly with Jency. I think you're ready to go. As long as Jency, you can hit record, I think we can open.
Okay. So I will call the meeting, the Wasco County Planning Commission meeting to order. Welcome commissioners, staff, and the public to the meeting. Thank you for your patience as we learn a new way of hosting public meetings in response to the governor's orders related to COVID-19. Oregon Revised Statutes 192.640 and 192.670 allow for public bodies to hold meetings via a means of phone or electronic communication. To ensure for public safety but increase participation, Wasco County has elected to hold all public meetings for the near future via video conferencing. Staff has prepared a public participation guide that was emailed to all registered participants on how to use the Zoom software. It is also available for download or view on the Wasco County Planning Commission page. We are also live streaming this via YouTube and on the Wasco County website. At this time, we'll ask for our staff to call the roll.
Chair, start with Vicki Ashley.
Here.
Russ Hargrave,
Here.
Brad DeHart,
Here.
Lynn McIntyre,
Here.
Mike Davis, Kate Willis,
Here.
Chris Shano has an excused absence this afternoon, Leroy Booth,
Here.
and Marcus Swift. And as for staff, I'm Angie Brewer, Wasco County Planning Director. And Jency Smith, our planning coordinator, is having audio issues, so I'll just introduce her for her. We also have a few others, Will and Kelly, if you're still on, do you want to introduce yourself? And Brent?
This is Will Smith. I'm Wasco County Senior Planner.
And Brent Bybee, Associate Planner.
Kelly Housley Glover, Long Range Special Projects Planner.
Okay, thank you. This meeting is being recorded and will be publicly available. All participants must mute themselves unless they are speaking. Lines that are providing feedback while not speaking will be muted to ensure others can hear. Only you can unmute yourself using the mic icon. If you are participating by phone, unmute yourself by dialing *6. Participants that are behaving inappropriately will be promptly removed from the meeting. The chair will specifically invite participants for public comment at the appropriate time, so please be patient and wait to be called upon. Please refrain from using the comment feature or the chat feature unless directed by the chair. It will distract from the intended flow of the hearing procedure. So next is public comment on items not listed on the agenda. And we will ask speakers limit their testimony to 3 minutes. So if there's anyone attending this meeting that wants to comment on items that are not on the agenda, you can unmute your mic and share any comment you have this time. Is there anyone that has such comments on items not on the agenda? Hearing none, we'll move on to approval of the previous meeting minutes. That's September 15th, 2020. Does anyone have any?
Madam Chair?
Yes. Vicki.
I move that we approve them as submitted.
Do I have a second?
I have a question before we go on.
Do I have a second?
Sure, I second it.
Okay, now, any questions or comments?
Do we need to approve myself as a voting member, given Chris is no longer or is not at the meeting?
Yes, we can take that up. Yes, all members, everyone that is participating today is voting. We have 6 members, correct, Angie?
That is correct.
Okay. Okay, is that sufficient, Angie?
I'm sorry, my dog is barking. I'm trying to mute myself.
Okay.
Typically, we have a motion to formally recognize the excuse me, I'm distracted.
Alternates.
Formally recognize the alternates as voting members of the commission.
Okay, can I have a motion to recognize the alternates as voting members today?
I so move.
Second.
All in favor? Say aye.
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 Okay. All right, now back to the minutes. I did have a couple of minor items in the minutes. One is that through most of the discussion, my name is spelled incorrectly. It's M-A-C, capital I-N-T-Y-R-E. On page 3, at point in the meeting of 52 minutes, 49 seconds, Shyla Olson, representing SWCD, stated support for agricultural exemptions and wished to continue offering exemptions for natural resource conservation and enhancement. Never mind, never mind, that one's fine. But I did at 56.07, it says, John Gill asks about variance to the 300-foot sighting rule. And I wondered if we could clarify what the sighting rule is, that we were talking about. Angie?
You want me to take that one, Angie?
Yes.
Yeah, that'd be great. Thank you.
That references within EPD 8, there's language that requires when citing a new dwelling, they need to be located within 300 feet of an access or roadway.
Okay, could we add that to the end of that sentence? And then, let's see. Oh, that was it. That was my only questions or corrections.
Pause you. Can I just pause you for 1 second? I'm sorry, I'm distracted. It doesn't appear that the meeting is being recorded on my end, and I just don't want us to get too much farther out without.
It is being recorded. Angie, I can confirm it's being recorded.
Thank you very much. That's why I'm like chasing all over the place, is I want to make sure it's being recorded. Thank you.
Okay, so we had a motion and a second, and I had some corrections.
Why don't we amend the motion? I think it was Vicky that made it.
Yes, I'll amend my original motion to accept the corrections as submitted.
Second.
I hear second.
Yes.
Okay. All in favor, say aye.
Aye.
Opposed?
Aye.
Okay, minutes approved. Okay, now we will open the public hearing for the purpose of Planning Commission's consideration for the appeal of land use application file number 921-19-000133 PLNG, denial of a national scenic area review to construct a 5,534 square foot, 80-foot long by 40-foot wide by 31-foot high single-family dwelling, and the retroactive approval of a 196 square foot, 16-foot long by 12-foot wide by 10-foot high accessory building constructed without land use approval. If a person does not otherwise have party status, anytime prior to the close of the hearing, the approving authority may authorize party status. Automatic standing is provided to the following parties: the applicant and all owners of contract purchasers of record as shown in the files of the Wasco County Assessor's Office of the property which is the subject of the application. All property owners of record as provided in A above within the notification area as described in section 2.080A2 of the property, which is the subject of the application. A citizens advisory group pursuant to the Citizen Involvement Program approved pursuant to ORS 197.160. Any affected unit of local government or public district or state or federal agency. Any other person or his representative who is specifically, personally, or adversely affected in the subject matter as determined by the approving authority. Any person who is heard by Planning Commission orally or in writing before the close of the hearing. The procedure I would like to follow today is first, the Planning Department staff will present their report. Second, the appellant and owner will then have the opportunity to testify. Third, the commission will then call upon anyone who wishes to testify in favor of or in opposition to the proposed use. Fourth, the appellant owner will then have the opportunity to rebut. Fifth, once there is no further testimony from parties who have not testified, the commission will then decide if it is appropriate to close the public hearing. Once the hearing is closed, the commission may ask questions, deliberate, and then vote on a decision. The rules of evidence are as follows. No person shall present irrelevant, immaterial, or unduly repetitious testimony or evidence. If you have submitted written comments, please do not restate it in oral testimony unless you have further information to add. Evidence received shall be of a quality that reasonable persons rely upon in the conduct of their daily affairs. Testimony and evidence must be directed toward the criteria that is applicable to the subject hearing. Failure to raise an issue accompanied by statements or evidence sufficient to afford the commission and parties an opportunity to respond to the issue precludes further appeal based on that issue. Any party of record may request that the record remain open for at least 7 days prior to the conclusion of the initial evidentiary hearing. Disclosure of interest of ex parte contact. Does any commission member wish to disqualify themselves for any personal or financial interest in this matter? Does any commission member wish to report any significant ex parte or pre-hearing contacts? Does any member of the audience wish to challenge the right of any commission member to hear this matter? Is there any member of the audience who wishes to question the jurisdiction of this body to act on behalf of Wasco County in this matter? Okay, at this time, I would ask for the staff presentation. All participants need to mute themselves and hold questions until the end of staff presentation. And so can we have the presentation, please, Brent?
Chair McIntyre, just before we get into that, I want to make sure, since we have had so much new comment come in the last 24 hours, that if you want to provide commissioners with a few minutes to skim that information before we get into it, or skim any of the information in the packet before we begin. Do you have a preference?
Do any commission members need the extra time to review staff summary or any new material that came in today? Okay, hearing
Okay, well,
none.
thank you very much. Brent Bybee will be doing the presentation today.
All right, thank you, Chair McIntyre. Also, I'll direct towards Mr. Khan, since we received an analysis from the Friends of the Gorge. When it comes time to testify, just let us know if the materials that were provided to us today, that I provide to the commissioners, if that's going to be the brunt of your presentation. That way we can decide if there's more time needed to review those materials. So, okay, moving into the staff portion, let me get my presentation up. Okay. Can you folks see that?
Yes.
Okay. Okay, good afternoon, commissioners. Today's hearing is to hear appeal of file number 921-19-000133-PLNG. The appellants are Mark Vanderzanden and the owner Tom Klimo. Let's see, I'm in trouble. There we go. The location of the property, it's located along the southeast side of Husky Road, approximately 260 feet west of its intersection with Gem Lane. It's approximately 1 mile southwest of the city of Mosier, as you can see on the map there. The request again was for a 5,534 square foot, 80 foot long by 40 foot wide by 31 foot high single family dwelling, as well as the retroactive approval of a 196 square foot, 16 foot long by 12 foot wide by 10 foot high accessory building constructed without land use approval. On a site visit conducted by staff, the following pictures were documented. The first one is taken at the proposed dwelling site looking north towards SR 14 and the Columbia River, which are both key viewing areas. As required in the scenic area, all development topographically visible from the key viewing areas must be visually subordinate. The next photo is the driveway constructed without review that extends to the southern property line where the accessory building constructed without review is located. This photo is leading up to the accessory building constructed without review. The picture is facing south towards the southern property line. The next photo is the north side of the structure and also shows the location of the outhouse, which was placed without sanitation approval from North Central Public Health. It's on the left there. And as you can clearly see from the photos, the accessory building constructed without review has access to bathroom facilities, contains electrical through a roof-mounted solar array, and also contains indoor plumbing with access to water. All of these characteristics fall under the definition of a dwelling. So I want to cover a rough timeline of the application process. On June 29th, 2018, staff held a pre-application conference with the applicant and the owner and a report outlining the required criteria based on the proposal was submitted to the applicant and the owner. On May 1st, 2019, staff received an anonymous call notifying the Department of Development on the subject property. And a corresponding email was sent to the property owner notifying them to apply for the development. On August 15th of 2019, after multiple reminder emails, an application was submitted for review from staff. On September 5th of 2019, an incompleteness letter was sent highlighting issues with the accessory building setbacks and dwelling reflectivity issues. And October 10th, 2019, additional information was received from the applicant with an incompleteness letter sent back addressing the issues with the accessory building setbacks. On February 6th of 2020, additional materials explaining how the development met the criterion was submitted by the applicant with no changes to the design, and the application was deemed complete with a pre-notice sent out the same day. On February 27th, 2020, Staff notified the applicant regarding issues with the amount of glass, size of the dwelling, and landscape setting criteria. On March 11th, 2020, additional analysis materials were submitted by the applicant stating how the dwelling met the size and reflectivity standards and why the accessory building is allowed without review. Staff sent subsequent emails discussing continued issues with size and reflectivity and accessory building setbacks. On April 6th of 2020, an amendment to the application was processed with the applicant's analysis and arguments that had been submitted, and another pre-notice was sent on April 9th of 2020. On July 2nd, a director's decision was issued for denial of the application, and on July 16th of 2020, an appeal was received from the applicant with a subsequent PC Planning Commission hearing scheduled. These are the review criteria required for the proposed land use. It includes listed criterion within Chapter 2, Development Approval Standards, Chapter 3, Basic Provisions, Chapter 4, Supplemental Provisions, Chapter 11, Fire Safety Standards, and Chapter 14, Scenic Area Review. Staff identified these criteria where the proposed land use was found to not comply. It's the criterion listed here under Chapter 3, Basic Provisions, Chapter 11, Fire Safety Standards, and Chapter 14, Scenic Area Review. On July 16th, 2020, the following grounds for appeal were submitted by the applicant, Mark Vanderzanden. I'll cover these in detail on the following slides, but please note, as stated at the bottom, that the grounds for appeal provided by Mr. Vanderzanden lack specific code citations and finding references. As a result, staff's response addresses the appellant's arguments to the extent practicable and focuses on the most relevant findings in code. So ground one is composed of these two statements combined. In addition, the planners state that the proposed accessory structure is located within a setback. The accessory structure was reviewed by the planners using criteria that is not required according to NSA rules. A decision regarding the accessory structure is incorrectly based on those criteria. A structure that is less than 200 square feet in size does not require the same siting criteria that homes and larger accessories require. Staff's response primarily is composed of code citations. Expedited Review Section 3.110.A.1 provides an expedited path for accessory structures sized between 60 and 200 square feet in area and 10 feet or less in height, as long as they comply with applicable resource protection guidelines and the procedural requirements of Chapter 2. As noted, Section 3.150C first requires qualifying expedited review uses to comply with Section 3.150G, property development standards, and Chapter 11 fire safety standards, as well as all other listed or referenced standards. Ground two that the appellant submitted to staff is composed of these two statements. It is clear that the planning department did not incorporate the detailed analysis and facts provided to them in their findings. Rather, they took a prescriptive approach to the allowable areas and sizes. The planning department's findings for allowable areas utilizes definitions that contradict both the NSA and tax assessors guidelines. The interpretation the planning department articulates significantly reduces the size of the home and unfairly applies a contradictory rule to this project versus other projects within the NSA purview. Staff's response, Wasco County Planning is the implementing authority for the portions of the National Scenic Area in Wasco County. Training is provided to the counties by the Columbia River Gorge Commission and the USDA Forest Service to ensure regional consistency in the regulation and application of the NSA management plan and to ensure an equitable approach for all affected landowners. Formal guidance is provided from the Gorge Commission and Forest Service, instructing county planning departments how to conduct a compatibility analysis for this rule. It was included in attachment F of the staff report. This methodology was used by staff to analyze the compatibility of the proposed development. Staff reached a fair and objective conclusion of inconsistency. This slide represents the formal guidance provided by the Gorge Commission and Forest Service on how to conduct the compatibility analysis. This can also be found in attachment F of the staff report within your packets. One item staff would like to highlight is the criteria related to calculating building size. As you'll see in the following elevation model slides, the lower level will be composed of a garage with the south side underground, 2 garage doors for access on the east side, 1 garage door for access on the west side, and the north side partially submerged. Instead of calculating the entire square footage of the garage towards the overall building size like the above criterion requires, staff utilized the daylight basement calculation and cut the garage square footage in half. Here you can see the east elevation model depicting 2 garage doors for access and the entire east wall of the garage exposed. And here you can see the west elevation model showing 1 garage door for access and most of the west garage wall exposed. And here's the north elevation model of the dwelling. As you can see, a small portion of the north wall is submerged with windows provided as well for the garage on the lower level. Staff's continued response. The appellant does not specifically state which definitions contradict the National Scenic Area guidelines or discuss why they contradict them. It's also not clear what tax assessor's guidelines the appellant is referring to. The Wasco County Assessor's Office does not apply the regulations or policies of the Scenic Resource Chapter, Chapter 14 of the NSA LUDO. The compatibility analysis included a study area of lands immediately surrounding the subject property that makes up the characteristic community of nearby development. It did not include other areas of the National Scenic Area or areas outside of the National Scenic Area. Structure size allowance is dependent upon the size of the existing development in the surrounding area and no other areas of the National Scenic Area. Ground 3 submitted by the applicant or appellant is composed of these 2 statements. The Wasco County Planning Department provided findings that the applicant structure contained too much glazing, which would create reflectivity. And also the analysis provides extensive evidence that the reflectivity will not be an issue due to location, orientation, adjacent topography, and screening. The amount of glazing must meet requirements for non-reflectivity, for which much evidence and analysis was provided. The planner's findings do not dispute the analysis, yet it is disregarded in favor of prescription, which is a significant limitation of what is allowed on this site. Okay, and staff's response, the proposed development must comply with scenic resource protections contained within Chapter 14 and must be visually subordinate to its surrounding landscape when viewed from designated key viewing areas. Staff's report includes an analysis of the proposed development. The staff report details visibility of the proposed development from key viewing areas and concludes with the finding of not visually subordinate due to large continuous surfaces that are topographically unscreened from key viewing areas. And just to clarify, continuous surfaces, I mean glass surfaces. To be clear, the glazing treatment would not cause additional reflectivity. Rather, the staff report concluded that it was an insufficient mitigation technique to reduce the amount of unscreened and continuous glass proposed on the structure. This slide includes an excerpt from the Building in the Scenic Area Handbook, which is a visual guide provided by the Gorge Commission and Forest Service for folks developing in the scenic area. This page discusses unscreened glass and continuous glass. The larger illustration provides a depiction of what is considered unscreened glass. So as you can see on either side of those trees, closely spaced windows that are unscreened, both topographically and with vegetation are open. And the illustration on the right side of the page depicts what is considered continuous glass. So the second figure down, you can see on the right, discusses closely spaced and also wrapping glass on the structure. And in comparison to the slide or the elevation model that was submitted by the applicant, here's an illustration of the north elevation for the proposed dwelling. Please note the large continuous glass surfaces that are topographically unscreened from key viewing areas. Staff's overall recommendation, based on the stated grounds for appeal, staff finds that the appellant does not have valid grounds for appeal and recommends that the Planning Commission uphold the decision of the Planning Director to deny the request with the findings staff has addressed in response to the appeal and with the findings and conditions described in the staff report. Does the commission have any questions for staff at this time?
I do.
Okay.
Lynn, may I?
Yes, please, Leroy. Go
Okay,
ahead.
the first question I have is on grounds 2 as far as size. What was the maximum structure in the immediate area, or do you define that?
Oh, let me pull that up real quick. It's in the staff report. Let me get that for you real quick. It was... And I'll hopefully be able to tell you the page number that it's on in the staff report as well. Okay, so it starts on page 25 of the staff report. And it was confirmed, so this is on page 26 of the staff report. Through staff's analysis, it was confirmed that the most compatible square footage that would be allowed within the area the subject parcel is located would be a structure with an overall visible mass of 3,248 square feet.
Okay, thank you. The other
And
question,
if you folks want me to share that on this window, I can do that as well.
Do any other commissioners have questions for Brent?
Yes, I do. Is Leroy, are you done, Leroy?
No, I had one more.
Oh, go ahead, Leroy.
As far as the sharing, I've got it up on my laptop, so you don't have to. When you were going over the glazing, I missed part of that. Could you go over that couple slides there one more time for me, please? I missed it. There was something you said and it went right by me and I was like, oh, what was that?
Right, let me get there real quick. Make sure that I'm on the right one. You mean the glass portions, the ground 3?
There had 2 different types of glazing, and it's like, okay, what was the second one?
Okay, can you see that?
Yes, I can.
Okay, from current slide. So you see staff's response there. Here's ground 3. You can see that, Leroy?
Yes, I can see it.
Okay, so which portion were you wanting me to go over?
Well, if you could just go over what you were saying again, because it was just something that you said, and I was like, it went right by me, and I was like, hold it back up.
Okay. Yeah, sorry if I went too fast. So staff's response.
I think I remember what it was, if it helps. You were saying that the glazing that was used did not sufficiently remediate or something like that.
No, so my last statement there, to be clear, the glazing treatment would not cause additional reflectivity. Rather, the staff report concluded that it was an insufficient mitigation technique to reduce the amount of unscreened and continuous glass proposed on the structure. So just to be
Okay.
clear, it's not the amount of reflectivity of the glass, it's the amount of continuous and unscreened glass that we based our, that we found the use to not be in compliance with the criteria, or to not comply with the criteria.
That was it. It was the, what, it was the reflectiveness that wasn't the issue, it was the amount. Thank you.
Correct. Yep.
That was that.
I have a question.
Okay.
Yes, Vicky.
In regards to the accessory shed or whatever we want to call it, it was unclear in staff report. Is that to be removed due to the fact that it's built without approval and it's too close to the line?
So I think,
Chair, I can take that one. So there is an ongoing compliance conversation as part of this review. The land use application was an attempt to remedy a code compliance element. We'll know more about how to move forward with that code compliance element when this process concludes. Whatever the outcome of this process is, it'll inform our code compliance conversations.
Okay.
I believe, Russ, you had a question?
Yeah, I have a couple. So I was just curious, the original dwelling then, this is accessory, the original dwelling was lawful then, Daniel?
so do you mean the accessory building that was constructed?
Well, so there is only one building on this 14.5 acre site?
Currently, right now, there was one structure that was constructed without land use approval. It does have the elements of a dwelling, and they are applying to also build a primary dwelling. And I think, yeah. Does that clarify for you?
Yeah, because it was called an accessory structure, so
Right,
it would be
and
accessory to, okay.
I believe that was the intent when it was constructed, but it does contain the elements of a dwelling.
And a dwelling is allowed in F3?
Yes, as long as it meets the applicable criteria, yes.
Okay, and the lot is smaller, I think, than the minimum size, but it was lawfully created?
Correct, yeah.
Okay. And I was just curious, so one of the issues would be, if this were an accessory building, that it is configured as a dwelling. That's what you said, I think, right?
Correct.
And there's an issue, isn't it the setback requirement from property line 50 feet?
So for the F3 zone, it's a little different than other zonings. Dwellings are required to be 200 feet away from neighboring property lines. It does not specify directly for accessory buildings. Staff didn't get too far into this because it wasn't addressed in the grounds for appeal. But in the staff report, we do address it. The fact that the criteria requires structures to not have an effect on neighboring forestry operations. That was part of the reason why we found it to not be in compliance with the property development standards, as well as the fire safety standards, since a 50-foot fire fuel break is required around all structures. The distance to the property line did not allow that, and a modification to the fire safety standards was also not submitted to have a plan to mitigate that.
Mm-hmm. And is there also, thank you, is there also a fire issue around the steepness of the slope?
For the dwelling or the accessory structure?
Well,
so for the existing,
so I guess which are we considering here?
So so there's two structures that are proposed: the primary dwelling, which is the 5,000 plus structure, and then the accessory building currently containing the aspects of a dwelling. Both structures in the staff report, staff detailed that there was not an issue with slope for either structure.
Oh, okay, thanks, thanks. And so for the dwelling that's proposed, is that 200 feet from the property line then?
Yes, yeah, it's more than that, I believe.
Okay,
Yeah.
so it's just the proposed accessory building that is
So I
relatively
should correct myself. It's a little bit under 200 feet from the northern property line, but there is a criterion within the property development standards that states if there's a neighboring forestry operation that you can locate the dwelling closer to roads and further away from that use, which it is. It's locating the dwelling further north on the property.
It helps, Commissioner Hargrave, the accessory building, it's proposed as accessory building because it doesn't meet the criteria to qualify to be approved as a dwelling. It can only pass through this permitting process with an approval if the proposed dwelling is approved. And that is the use that was denied in the appeal, the grounds for the appeal.
Thank you.
So if I understand what you're saying is it's an accessory building.
It was
Currently, that's the definition. It is not a dwelling.
It was proposed as in the application as an accessory building, but it does contain the aspects of a dwelling.
Okay, but to the question as to whether or not it can stay or remove is based on the fact that you can only have one single family dwelling on an F3. So if it is a dwelling, then it has to be removed when they put the new one in.
Or
So it's not actually the question on the table, if I might just kind of bring us back in. If the larger dwelling, the proposed dwelling is not approved, then the other building is not allowed because it's not accessory to anything, and it will be part of a code compliance conversation moving forward.
Okay, it's a little confusing, but okay, thank you.
I might say that the accessory building there now is not accessory to anything.
Correct.
Traditionally, and you can't put up an accessory structure without first having a principal dwelling or principal structure, so.
Correct, and that was why staff came to the conclusion that the structure would need to be removed.
Okay.
Thank you.
Other planning commissioner questions?
No more?
Okay.
Okay, I'll just cover kind of where'd it go? Can you folks see that?
Yes.
Okay, so next we're going to hear testimony from the appellant and the owner, followed by questions from the commission. And then after that, we will hear testimony from the public in favor of and in opposition to the development, followed by questions from the commission. And then we'll also have an opportunity for the appellant to rebut any testimony provided. So thank you.
Okay. I want to remind all participants to state their name and address for the record that want to testify. We use this information to contact you about the decision. So at this time, we'll ask for the appellant or owner if they would like to testify.
Yes, we would.
Okay, please state your name and address for the record, please.
My name is Mark Vanderzanden. I live at 3265 Southwest Fairmont Boulevard in Portland, Oregon.
Okay, thank you. Proceed.
I have a question on, may Tom and I do this presentation together where we both take turns speaking, or do you need us to speak one at a time?
Angie, I believe that would be okay, would it not, if Tom gives his name and address for the record as well?
I would agree, yeah.
Okay.
We've allowed that in
So
previous hearings.
if Tom wants to come in now and state his name and address for the record, then you both can do that.
Thank you.
Thank you, Madam Chair. Tom Clemo, 2520 3rd Street, apartment number 10, Santa Monica, California, 90405.
Okay, thank you.
And I've got a PowerPoint presentation I'd like to be able to put on the screen. think I might need a bit of instruction on how to provide.
If you hit share screen down at the bottom there,
Got it.
it should pull up a window for you. And if you have the PowerPoint open, you should be able to select it from there. There you go.
Everybody see that?
Yes.
Yes.
Thank you. I'd first like to introduce myself and the sort of body of work that my firm has done in the Gorge. My first project in the Gorge was in 1992. I designed a home in Hood River, and since then my firm, Surround Architecture, has designed probably 60 projects in the Gorge, ranging from homes such as the one I've set up on the screen to large and commercial buildings, industrial buildings. We've got a school project under construction over in White Salmon. Most of the work of my firm is in the Gorge. We've done quite a few projects that have gone through an NSA approval process. This picture that I've got up is the very first one that I did. It's in Hood River County. This is the Ball residence, which we did in the year 2000. And this house is literally a quarter mile from a key viewing area. And it's very similar to the house that we're gonna talk about for Tom, in that it's faces north, has quite a bit of, I'll call it continuous glazing. It's got oak trees that sort of surround it that provide screening. And this house is literally, like I said, a quarter mile from key viewing, and I've never been able to really pick out this house from a key viewing spot. I've tried, you can maybe do it with binoculars, but what I hope to go through today is sort of our building science analysis on how we design these homes just to be visually subordinate in the National Scenic Area. And you know, we've done 10 or 11 NSA projects, mostly in Hood River County, but we have previously permitted one in Wasco County down at Rowena Dell. We've got several in Skamania County, one in Klickitat County, et cetera. So my firm has a tremendous amount of experience managing, I'll call it building science, so that we can create the visual subordinate that's required. This other project is one that we did, I think, in about 2005, that is on Cook Underwood Bluff. And again, it's, you know, this project is probably slightly visible, and it's on Cook Underwood Bluff. It faces south, so it has a much different set of issues facing south with the sun hitting it directly than a house that faces north. And so a lot of the things that we do is we look at very site-specific issues, and we did a lot of analysis on Tom's house, and we introduced quite a few strategies to sort of make this house visually subordinate. Again, having done these projects for so long, I always staked my reputation on having projects that meet these goals, and I've never had a project that has had a problem. And so I'd just like to put that out there. That's our approach, and it's always been quite successful. I'd like to introduce Tom, who's our client and the homeowner.
Hi, good afternoon, everyone. Madam Chair, members of the commission and planning staff, Will and Brent, good to see you again, albeit virtually. I apologize if the internet connection is a little bit jumpy. I'm in our satellite truck on the Dolan fire incident, and hopefully it's quiet in here and we have good satellite uplink for everybody. I've had a lot of opportunity to reflect about this project. Just in general, I work for the fire department in Southern California, and this piece of property and this project is my retirement plan. So after spending now 33 years in the fire service and 18 of that in Oregon, my intent is to move back to Oregon and embed myself further into the community and move to Mosier, and really that's kind of the goal. So when we started this particular project, I'd like to address a couple of issues that have come up. Number one, I've had I read all the letters that we received last night, a lot of boilerplate type letters, but the message is not lost on me. We intend today to present to you an alternative design to the structure that cuts the glass by over 35%, breaks it up, makes it, I believe, a more appealing home, and hopefully does a better job of addressing the concerns that we heard from not only my fellow neighbors in the Mosier area, but also, frankly, the concern that's been sent to us by staff. So we are prepared to present that today. In terms of the size of the structure, I'm also open to do what we need to do to fit a little better in the neighborhood. But I would say that a lot of my neighbors live in single wides, and these particular homes have not been purchased and developed to build a larger structure on it. When we looked at the site, and what appealed to me on the site is I could build this house without taking one tree out. And I could build it in a place that not only provided a view of the river, but was hidden by the trees and buried into the slope. Rather than choose an option of building it up from the ground, the option to bury it and hide the basement was pretty critical to me. Additionally, a lot of the infrastructure for the home, including fire sprinklers, a water tank, and other a battery and other efficient items I want to put into the house, are stored within that basement space. So the environment is a big part of this project. So I guess what I'm saying to you is I get it, and I understand that we need to make some concessions here. We've had some challenges in that conversation, to be frank. My hope today was to have more of an open dialogue, similar to some of the questions I've already heard about where we are with the not only the home, but the accessory structure. And I respect the opinion that it's hard to have an accessory structure when there's no primary structure. That's accurate, and I own that. My intent for that accessory structure was to store all of my tools for the project, and it's a nice place to sit in the evening. I have a water system up there that is just a 55-gallon drum that I use attached to a garden hose for fire purposes, for hosing the porch off purposes, for things like that. It's a little small for me to be living in, that's for darn sure, and that is not my intent. It's a secure location that is completely out of view, that is on my property, and I would like to intend to use it as a place I could just walk up from the house and enjoy an evening with some friends, and that's the intent. So there is not an intent to live in that, to answer the commissioner's earlier question. My hope from today is to engage in, or be allowed to engage in, a collaborative and collective conversation about achieving a dream of building a home on this property site, and working with Brent and Will or other staff members as assigned to do just that, to address the concerns of the amount of glass that is on the house. Again, you'll see a design that's significantly different to that end, and to discuss some options moving forward. I take some of the concerns that were expressed in the staff report very seriously, especially in the business that I'm in. It's absolutely my intent to not remove any trees, but also to have it in a fire-safe environment, to build a structure that is such, to sprinkler it, which is not required, to provide accesses access to my water system, which is not required for the fire department, and to try to get through this process. So I again really appreciate the commission's time today. I apologize for taking up your time on something like this. To the planning department as well, I know they put an immense amount of work into this, into a very extensive report, but frankly, so have we. And it's my hope that we can get to some good direction on this. And again, really appreciate your time today. Thank you.
Thank you.
So I know that the staff has already mentioned appeal grounds, but I kind of want to just go through things, and I guess in my own words, and I apologize for not doing it quite specifically so that it was easier for you to address, but I just kind of want to go through in my own words what we feel, what we'd like to talk about in this hearing in terms of how we approached it. And one, we believe the application of the site planning standards relative to the accessory structures is applied incorrectly. We do find that we feel like some of the staff report findings were inaccurate, and we believe that the application of the compatibility methodologies is somewhat unfair. We have some evidence of that. We can talk about that here in a minute. And we believe that we have provided ample evidence of complying with visual subordinates requirements. I guess it's always been my understanding of the NSA is that, you know, the law requires visual subordinates. There's really no specific ordinance that says you cannot have uninterrupted expanses of glass in you know, written ordinance. That's certainly a recommendation for people that need prescriptive requirements to meet that visual subordinates. But as an architect that is trained in analyzing all the aspects of what goes into a building, we believe we can provide ample evidence of complying with visual subordinates without having to rely on those prescriptive ways of looking at things. We'll show you some of what we did with that here in a minute. You know, as Tom mentioned, you know, we've provided a lot of evidence to that effect, but I think it's somewhat clear that we didn't convince quite a few people. And so we are, you know, Tom wants to build a house. I'm certainly not here to beat a dead horse. So we do have some alternatives at the very end of this presentation that we'd like to show you. Project history. I just want to make this one point about the pre-application conference, and on Tom's behalf is we did come to the pre-application conference showing this accessory structure, which is located right here on this drawing. So this drawing was provided to Wasco planning staff prior to the pre-application conference, and was presented as the location for an accessory along with the house that was proposed in a location here. And I didn't realize what might happen, but I'm pretty sure Tom left that meeting thinking that a structure that was between that was less than 200 square feet, 196 feet, actually didn't require an NSA review. And I certainly wasn't going to advocate for that, but I think that was the situation. And I think, for better or for worse, it was obviously a definite misunderstanding, because we came in and presented this particular location for an accessory structure as part of that meeting. So when we started this project, though, we understood that a house that with Tom's goals was going to be a really challenging project to get approved. And we were told that at the pre-application conference. I think Will and Brent were clear with us that, a house with the kind of size and glass that you're talking about was going to be difficult. And I would not suggest otherwise, that they didn't tell us that that was going to be a challenge. So we, as an architect, came up with quite a few strategies for how to mitigate the size and potentially glass of this structure. We wanted to locate actually the accessory structure in a non-visible location. Tom wanted a place to have a storage place. He mentioned that it would be for during construction, which I think makes a lot of sense. And, I think one option for this discussion is to look at it as a temporary use. And it could be a permanent accessory structure after its temporary accessory structure use, because it kind of makes sense to have an accessory structure while you're building a house. But that location where it is not visible from a KVA. It's one of the few places on the whole property that wouldn't be visible from a KVA. So we thought it was a pretty strong location for an accessory structure. The locations that would be approvable using the site planning standards would locate it near the road and then visible from a KVA as by comparison. We wanted to locate the home in a location to minimize visibility, and I think the staff report actually says, agrees that the home location was fairly well strategized to achieve that goal. We wanted to locate the home in a location that does not require tree removal. Tom mentioned that. That was real important to Tom. We worked hard to create a spot and that could achieve that goal and meet some basic requirements for a driveway, et cetera. The trees were real important too, to locate the home in a place where the trees would provide the most screening. And then, this is real specific. We wanted to orient the home to reduce the possible reflections of the sun. We wanted to place all the utility functions underground to minimize size. And this is where I think, this discussion that we had is, I think there's quite a few homes in that area that might have a home and then a separate, much larger accessory structure that would be like a barn or a utility building that would have cars or tractors and that kind of thing. As well as a water tank, which Tom wanted to provide. And Tom mentioned, he wanted to put the water tank underground. So basically, our strategy was to put all that stuff underground to sort of minimize the size of the structure. And, that's quite a bit of stuff. And so that underground space is pretty big. But again, our goal was to limit the size of the house that was essentially above ground to this 2-story structure. And this is a strategy that I think is extremely effective, and I feel like it's hard to explain adequately. And so I'll try my best. But we wanted to use a faceted facade. So the facade that faces the KVA has facets. It's actually a subtle, I'll call it curve, but it's made up of 5-foot wide facets. And I'll show you a drawing of that in a minute, but each facet is only 100 square feet. So our thought is because the guidelines suggest that you only have 100 square feet of glass, that we would essentially create a separate facade, if you will, for each 100, for each 5-foot width by 20 foot high. So each 100 square feet has a different facet, so that when light is reflecting on each one of those facets, only one of those facets could possibly reflect directly the sun, and that any one of those facets would probably be reflecting more likely what's around it, which is trees or topography, etc. So this facet idea was to us a really important strategy to minimize the size and the visual subordinates of the structure. And then lastly, we proposed using a museum grade glass that has the least reflectivity available on the market. I'm not sure if you've visited the Apple store in Portland, it has this glass that we've shown using. It literally has no reflectivity. And so what I'd like to believe that the NSA rules for visual subordinates are for just that, and not just the prescriptive elimination of glass. Because if we're using a non-reflective glass, it ought to be used in the same way that we would use stucco or wood siding, because if it's not reflective, it's not reflective. And that's the reason something would not achieve visual subordinates, is if it's reflective. So if we eliminate the reflectivity from surfaces, whether it's glass or metal, we seem like we meet the visual subordinates requirements. As I mentioned with the glass, we've also provided evidence of using specialty coatings on metals. And on metals, you can get down to essentially zero reflectance using the proper coatings. Glass, you can get down to probably 2% with museum grade glass. If you ever go to a frame shop, you can choose between regular glass and reflection free glass for your prints. And that's what we're talking about using for this house. So the key issues of the denial: location of the accessory structure, compatibility of size of the residence, and the reflectivity of glazing and metal. I'm going to start with the location of the accessory structure. Again, I'll just repeat it. The location is the least impactful of KVA views compared to a location where it's clustered near the home. This is completely hidden by topography. And then again, it's our observation that accessory structures that are less than 200 square feet do not need to comply with the planning standards due to its small size. And that's per the management plan for the National Scenic Area, the management plan that was produced by the Gorge Commission. That's the way it's written. So when we've been discussing this with the county, we're saying, no, we understand that you're applying your rule the way you are, but what you're applying is different than what the Gorge Commission has set forth in their rules. And there's been some discussion about the concern from the neighbors having to do with fire safety or things like that. But the concern from the neighbors has been limited to a boundary issue, and just they want to make sure that there's nothing that gets approved would be on their parcel. And so we sent a couple of things for you to see. Hopefully you've got them. We sent 2 letters that came from the Husky family, which owns the parcel to the south, that discusses their concerns, which are, again, limited to boundary issues. So I don't think that issues associated with a storage of equipment would necessarily cause any complications to the operations of what might happen on the parcel to the south. And in addition to the things that we're talking about today, I believe that the county has the opportunity to even have variances from the setback standards. So to me, it's like the location of the accessory structure could easily, I think the county could easily have written findings that said, well, we think that actually this location is best because it's hidden from KVA views and it complies with the essential standards of the zoning code. This is the portion of the Gorge Commission management plan that I'm referring to, that I think has been a basis of what we've been talking about the entire time. It's from the Gorge management plan. It's not from the Wasco County Code, I admit, but I believe that what you're trying to implement is the Gorge management plan. So that's why I'm referring to it. And here it notes the difference between accessory structures, which are less than 200 square feet or different than the 200 square feet, versus accessory buildings, which are larger than 200 square feet. And what you'll see is that if it's an accessory building is larger than 200 square feet, then yes, it has to adhere to the approval criteria for siting on forest land and approval criteria for fire protection. But the accessory structures that are less than 200 feet do not. They basically just have to adhere to the expedited review standards, which are quite limited. I didn't add all the information from the Gorge Commission Management Plan to this presentation, but that's the basis of what we're talking about here. That the Gorge Commission Management Plan is, I think it's allowing accessory structures that are less than 200 square feet to be placed anywhere, basically, because they're small. They would have their effect would be limited, so they do not need to. They are not subject to these two specific approval criteria. So one of the other issues is compatibility and the size of the residence. And I've already mentioned how we took this strategy to try to bury a lot of the uses. I also would like to talk about the methodology the county used, because it's frustrating as a designer to sort of understand that the discrepancies between different parts of your code versus how the planner applies a methodology. This particular bit of text is from the county's planning code. These are the definitions, and they're definitions from the Wasco County NSA ordinance. And it tells what floor area is. It says floor area is measurements is exclusive, meaning it does not include unfinished attics and basements, attached garages and carports, and covered or uncovered porches, decks, and breezeways. It does not include those. That's the definition of floor area. So when I filled out the application for this house, I listed it as 3,148 square feet. It's not 5,000 and some square feet, because that's the definition of the floor area based on your own zoning code. And in addition, there's definition of basement from the NSA ordinance, and because we have to define what an unfinished basement is. A basement is a portion of a building partly underground, which is less than 1/2 of its height measured from finished floor to finished ceiling above grade. And it's not deemed a story unless the ceiling is 6 feet or more above the ground. So this space that is created is absolutely considered a basement. It's definitely partly underground, and it's less than 1/2 of its height measured from finished floor to finished ceiling, meaning the average grade is always greater than half. And you'll see in a second in a diagram, I'll show you that it's definitely greater than half. So it definitely qualifies as a basement. And I have to do this all the time, say what a basement is to meet code as well. So the definition of a basement is consistent on your planning code as well as the building code. And in addition, you have a definition of gross building area, and that's the total area taken on a horizontal plane at the mean grade level. So the mean grade level is anything above a basement. And again, that's a consistent term used for the planning code as well as the building code. And so the reason I think this is especially important to talk about is because those definitions are consistent on your building code and your planning code, so that when somebody goes in for a building permit, they generally would get a building permit for the area that meets these definitions. And if you get it, so when I go in for a building permit for this house, assuming it got approved, I would go in for a building permit for a 3,148 square foot house, not a 5,000 and some odd square foot house, because I'm meeting these definitions. And I think if 3 years from now, when it shows up on a tax roll, it's going to show up as a 3,148 square foot house, not a 5,000 square foot house. So if you look at the if you look at the county's methodology, they wanted to compare this to the neighbors' houses. And so the county, as I understood it, they took the neighbors' houses from the tax rolls. I believe that if you check the tax rolls, you will not have covered outdoor areas included. You likely would not have unfinished basements included. You would not have carports included, and you would not have decks, etc., included. Some of the things that supposedly we're going to be compared against. And so I feel like the methodology, which I understand is relatively new, I think the methodology was introduced just this year, has probably some bugs to work out, because it seems unfair to compare, this very specific set of areas on this house with the tax rolls, unless you go out to the specific house that you're looking at and compare what's actually there against the tax roll. Again, I think you would find that there's a lot of stuff missing from the tax rolls. I called the tax assessor and tried to find out what would be included in it. I got an answer of like, well, it's not sure. I'm not sure, depending on when the house was built, it's not clear to me whether an unfinished basement would be included or not. If it's newer, maybe. If it's older, we don't know. If a house was built in the 60s, it's probably just the floor area and not including a lot of those other things. So, there's that aspect to it. And then I think there's just the aspect of it that literally we think that this whole basement area should be counted as 0. And I say that because this little graphic here, the orange on the left is the area of the house that is above existing grade, and the yellow is the area of the house in section. Sorry, the area of the house in section that is above grade, and the yellow is the area of the house that is below grade. So if I bring in the elevation, you can see what we tried to do. This area is above grade, yes. I don't feel like that should constitute it as a daylight basement. And by the way, the county definitions, the zoning code, there is no definition of a daylight basement. So, we struggled with that. It's like, how do we, unless we just get rid of this, how do we come to some agreement on this? This whole area is below grade. A portion of the level above is below grade. We had some outdoor area that is below grade on the south side, and so we really just think that this ought to be considered 0. I mean, it's so much of this house is below grade, because the alternative is to get rid of all that. If we got rid of this basement entirely, we could build this house without a basement. This little bit right here would be a crawl space. And then it would be a house that would be 3,148 square feet. And it would look the same. It just wouldn't meet the same size calculation that the county has put together, that the staff has put together. So, personally as a design professional and all the work that I've done, this area ought to not count as area based on definitions, based on precedent, and based on just the visual of it. And lastly, reflectivity, the glazing and metal. Staff already showed this. This is the house site, and there is a key viewing, two key viewing areas that are visible from the house. Staff calculated it as a mile stretch of Highway 14. My calculation is less than that, but I think it probably doesn't matter. It's a little bit of the river as well. So we did quite a bit of analysis of reflection. And again, this house faces north. It has quite a few trees around it. That's the starting point. We've buried a big chunk of it. That's another starting point. But when we looked at reflection, we were, mostly concerned about the direct reflection of the sun. And again, this is north, so there are times of year when in the summer, probably about 4 months out of the year, where the sun at the late in the evening and early in the morning is beyond beyond the house, so it could actually strike the north face of a facade. But the reflection is highly scientific, and this diagram shows how it works. This is the angle of the sun hitting a mirror, and this is the angle that it reflects. So when you look at it in terms of the cross section of the gorge, the key viewing area is down here at about 250 feet of elevation. The house is over here at 800 feet of elevation. And so to get that reflection across that axis, the sun would need to be in this location, which is roughly 1,200 feet of elevation. And that's the only time it could possibly reflect back to the key viewing area is when the sun is in an elevation, roughly 1,200 square feet. Now we calculated because of the 2.1 miles away, that there might be 5 minutes in the morning and in the evening where the sun would be at the proper elevation that would strike that. Now that's only, again, if it's the right time of year. But the house also has ridges on both sides of it. There's a fairly substantial ridge to the east. And I think staff even concluded, well, there's no way that the sun would ever hit the house from the east because it's the hills to the east are much higher. And there's also hills to the west, which rise up 1,300 feet. So the problem with the sun hitting the glass at this 1,200 feet of elevation is the fact that there's hills in the way. This diagram shows the reflection characteristics in plan, because it's the same characteristic in plan. If the sun's coming from here in the morning and striking this facet of the facade, it's going to bounce off in this direction. It's not just going to bounce off anywhere, and it's not bouncing everywhere. It's bouncing in a specific direction because that's how light works. And so this diagram shows that all the facets that we have, there's several here. Each one of these is a separate reflection because we've separated all those pieces of glass into different directions because they're faceted. It shows that none of the reflections fall into this cone. This cone is where the view corridor from the key viewing areas. And in addition, in the morning, there's a really large oak tree right here, which I think would completely block any sun. Now, I've already mentioned, I think there's topography that blocks the sun from hitting that house at 1,200 feet. But in addition, there's several trees, this one being the key one, that would block the sun in the morning. And in the evening, again, this is the worst case scenario. This is summer solstice. The sun gets to an angle of roughly 65 degrees or something, thereabouts. This is well calculated, but it's roughly, actually I've got it on here. I can't read it, it's too small. It's listed right there. But that's the sun angle coming in, and then if it strikes this facade, it's actually striking each one of these facets, and then each one of these little reflections is a separate angle, a separate direction, a separate reflection. If this could happen, if I was wrong about the topography and this could actually hit the glass, only one facet would come into this key viewing area right here. So that's this one, this particular facet. This one misses it, that one misses it. The other ones definitely miss it. So one facet would possibly reflect, and that one facet is 100 square feet. That one facet meets the guideline for how much glass could be reflected back towards a key viewing area. So in addition to the topography, this plan shows a series of oak trees on this side of the house. these two trees right here, which are relatively close, are both 30 feet tall. This one's also probably 25 feet tall. These three trees alone also screens the sun. If it somehow snuck past the topography of the hills to the west, it would then hit these three trees before it struck the house. Not only are there trees blocking the sun that strikes the house, but there's a series of trees in front of the house that would actually block the reflection. So I mentioned topography. This is to the west, which I think is, the place where it would matter. The home's over here. This is, again, this line right here, the summer solstice. There's a ridge right here that is 1,300 feet. This ridge is 1,100 and 1,200 feet. This ridge over here is 1,800 feet. This is summer solstice. This is probably something like August. The 1,300 feet. The 1,300-foot ridge would absolutely block the sun from hitting, again at that angle where it could reflect back across the river. When we were this last summer, we analyzed this. We were out there at the site, and the sun is obscured by this ridge, this one right here, at summer solstice, a full half an hour before it's the official sunset, and that's because this ridge is so high. So I'm going to go back to this little diagram. Oops. Actually, I'm going to go back to this one. Again, this is reflection science, and the reflection of the sun, about an axis towards a key viewing area. And there's also the discussion of well, if the sun doesn't hit the glass, it's also going to have a general reflection of a blue sky or a gray sky. And although that's probably true, the reflection works the other way, where what's really being reflected, if it's not the sun, is what's, again, opposite the axis. So it's actually this hill right here would really be reflected, not the sky. This ridge right here is 2,000 feet tall, and you can see this reflection, if I keep going, would be the Gifford Pinchot Forest and not the blue sky. If you ever look at buildings and you can see that the glass is really reflecting not sky but something else, it's because it's really reflecting what is opposite about an axis. And then I mentioned the type of glass that we can use. This particular glass is an insulating glass unit that would meet the energy code. It is 6% of reflectance, visible light out, 6%. That's roughly half of what the minimum reflectivity, maximum reflectivity, sorry, half of what the maximum reflectivity is that the county requires. We also provided a sample, we provided a cut sheet and product data for this 2% glass that is made by Pilkington, which again is the same glass that's at the Apple store. So we can specify glass that is down to 2% reflectivity. I took this actually yesterday. This is in the Dalles near the mall, just behind the mall, looking up at the ridge. There's a couple houses right here, and it's the north, and it's just so hard to see anything on this on a north-facing facade because of just the dynamics of light. And admittedly, in the evening, the things change quite a bit, but you know, again, having done these projects for so many years, I feel like I can stake my reputation on the idea that there would not be any. I think you would actually not see this house from a key viewing area because it's really over 2 miles away. This is barely a half a mile away in this photo, and there's an expanse of glass there that you just can't see because, again, it's facing north. We provided a bunch of information on how to provide coatings for metals so that you can get coatings down to, you know, less than 1%. If you have a coating that's like 2%, you know, it's essentially not reflecting anything. And there's a variety of coatings, you know. That's why you can have a stealth bomber. You can provide something on a piece of metal that can essentially be invisible. I just wanted to mention these trees again because, again, if the sun is trying to come through that area that I talked about, it's trying to come through these 2 trees or this tree, and it's trying to reflect back down through these trees. So I would like to believe that the rule is really that we're trying to make a house visually subordinate and not follow a restriction where you just can't have glass. You know, as an architect, I think there's always a way to make a house visually subordinate without having to go to prescriptive measures. Now, finally, don't want to beat a dead horse either. So we are perfectly comfortable providing solutions that would reduce the amount of glass, and we provide this sketch as an option. We sort of have to get past the size standpoint. We could also reduce the bulk by lowering the house. If I lower the house a couple more feet, I'd be down to just 2 or 3% of that basement being above grade, as opposed to the 7 or 8% that it is now. So we'd be willing to do that. I don't know if this hearing has the opportunity to create a process to try and still get an approval, but you know, that would be our approach. I mean, I think we didn't necessarily want to have to be in an appeal process. We didn't actually think we would end up this way, to be honest. I included this email because in roughly June, Tom had emailed Brent with this note that says, you know, gosh, can we, you know, first he makes note of the fact of how challenging things have been. And Tom, you might want to speak to that. I don't want to, you know, blame COVID and civil unrest from riots, but, you know, we had a hard time keeping our focus on this project. And so, you know, I'm going to apologize to say why we're, you know, apologize to be here and appeal. In June, we tried to say, gosh, you know, let's talk about reducing the amount of glazing. And we got an answer. It's like, well, it's too late. And so, well, if it's too late, we'll go to an appeal, present our case to this commission, and you know, essentially that's why we're here tonight. So, summary. I really do believe that this is true, that the accessory structure does not need to meet the site planning standards since it's less than 200 square feet. I think for a variety of reasons, we ought to talk about the size of the home being compatible, you know, based on however you want to look at it. And then, you know, the reflectivity, I would stake my reputation on what we provided, but on the other hand, I think, you know, we want to build a house, and so we're here with our tail between our legs, so to speak, trying to talk about compromises. And we'd love to be able to have that opportunity if we can. Tom, would you like to add anything?
I appreciate that, Mark, and for Madam Chair, members of the commission and staff. My eyes kind of roll back when Mark goes through some of the complicated analysis associated with reflectivity. But if I put it into something that I understand, is after spending quite a bit of time standing in the exact spot where that home is supposed to sit and trying to envision what it would look like at all times of the year and all times of the day. I don't believe that the reflectivity is the issue that it's portrayed to be, but I do understand and respect the opinions of my neighbors and the groups, the individuals that wrote letters last night, and hence the alternative design of the home. As a starting point, we hope for an opportunity to have some conversation about what do we need to do to get to yes on this. And again, if it means lowering the house further into the hillside, if it means reducing the width of the house so it's deeper rather than wider, or just a little bit narrower than it is right now. I'm certainly open to those conversations. Again, as I stated in the beginning, I'm really hoping that this is a conversation about collaboration to try to get this done. I am not, I got a few years to go to retire and I've got a lot of time, but I do want to I want to do it right. And to that end, when we did leave that meeting in June a few years ago, I was under the impression that it was okay to build an accessory structure, and it's my fault that I didn't get that in writing or further run that to ground. And I'll blame that on my own personal excitement to want to have a place to stay when I come up there and crash on the porch and keep some items up there in preparation for this project. So I'm hoping we can have a conversation about that. I with Mark agree that I'm sorry to have to tie up an afternoon with this conversation, but hoping we can move forward. So thanks again to the commission for their time and attention to a complicated presentation, and look forward to any questions. Thank you very much.
Thank you. At this time, does the commission members have questions for the appellant?
I have one question.
Yes, Leroy.
Mark, when you went through and did your presentation, you looked at the reflection and stuff. Did you take into consideration the cone effect of the reflection?
Yes.
And what were your findings with that?
That the cone reflection of the sun is approximately 2% at 2 miles.
So would that push the sun above the hillside?
Are you talking? No, well,
because you have a reflection of a cone both ways.
The cone effect would be from the reflection off the glass towards the key viewing area. I don't believe that there is a specific cone effect from the direct effect of the sun, because the sun is highly specific. You know, once the sun's behind a hill, it's behind the hill. There's no cone effect. Now there is a cone effect from the reflection, though. It literally disperses and gets wider as it goes across. You know, as it's traveling back towards where someone sees it. There's a very specific a cone effect.
Okay. I was just curious if you had taken that into consideration. Thank you.
Is that it, Leroy?
That was it.
Okay. Other questions from the planning commissioners?
Yeah, I have one then.
Yes.
So I think it was Mark, you were presenting and you had a slide that summarized the remedies that you were proposing. Could you show me that slide again? Do you know what I'm referring to? Yeah, thanks.
Well, yeah, I mean, it would probably be helpful to talk about that a little bit more, because, you know, I think the accessory structure is a little bit of a lightning rod to some degree, because I think it was placed, you know, put in place without a permit. But I do think that two things. One, it's a great location for it in the sense that it's hidden topographically, and so it achieves quite a few goals in that regard. And I think, you know, from my analysis and looking at, again, the various ways that I think the county could have approached this, that they could have written findings that would have allowed it in that location. There's even variances to setbacks. There's a variety of ways to treat that. And so understanding that that's a bit of a lightning rod, I think that's a good solution to this, Tom's need to have a structure.
The things that sorry to interrupt, Mark, but what I was looking for is, I think, the bottom two bullets, because those are things you're proposing to change versus debate.
Yeah.
Okay.
Oh.
I mean, it seems to me that the structure was placed unlawfully because it's a dwelling. So with or without the 200 square foot issue, it I think has issues around it being built without any authorization. But thanks, this is what I wanted to look at. So it's the 33% reduction in glazing and lowering the the home further.
Correct.
Okay, thanks.
Any other questions from planning commissioners? If there are not, then yeah.
Commissioner Willis, is that question directed to me?
Mark.
I sort of hate to say this, but I feel like virtually everyone I've ever done has had that situation where it's been a collaborative process where, we can show that we're doing things beyond the prescriptive methods. But at the same time, there's some give and take so that, because we understand, I understand that you have a problem if you approve this in terms of precedent and everybody pointing at it and going, wow, you approved this, house with all this glass. And I understand that. I feel like the reason we're here is because we never had that opportunity to have that give and take. And, I don't really want to slight the planning staff. I honestly think, in my humble opinion, this year has been really challenging to work. Everything's remote. We've had a hard time communicating because of, not being in our office and not being able to answer phones and all that kind of stuff. So, I feel like we ought to have that process. And so again, I'm apologizing for being here. To be honest, I've never had a project appealed, and I assumed at some point we would, sit down and work some stuff out, but we really didn't do that. And, maybe that's my fault for not understanding when to do that, but normally we do that after the, in the various jurisdictions, I've often done that with staff after I've submitted everything and they've received comments back from the various agencies or stakeholders. We would have that conversation. And in this case, we did all that, but then we never had that conversation.
Are there any further questions? If no further questions at this time from planning commissioners, then we will move on to audience participation. Are there any individuals with party status or members of the audience who wish to speak in favor of the proposal? And if there are, then state your name and address for the record.
Chair, I'm sorry to interrupt, but there is a list of pre-registered individuals that Jency's prepared to read off from, just to honor that registration.
To speak in favor of the proposal?
I don't see any that indicated they were speaking in favor of the proposal.
Okay. Are there any individuals with party status or members of the audience who wish to speak in opposition to the proposal? If so, unmute yourself and state your name and address for the record. And Jency,
I have the list. The first one on the list is Gary Kahn.
Thank you. Good afternoon, Planning Commissioners. My name is Gary Kahn. I'm here representing Friends of the Columbia Gorge. Friends is a nonprofit organization with approximately 6,500 members dedicated to protecting and enhancing the resources of the Columbia River Gorge. Thank you for this opportunity to comment. We submitted written comments this afternoon. My comments are going to just distill the written comments down to what we think are the most important parts. Friends supports the planning director's decision to deny this application as currently proposed. The applicant proposes to build an incompatibly large glass-faced house in an area of the National Scenic Area that is topographically visible from multiple key viewing areas. This large structure with the vast expanse of reflective surfaces, would unlawfully damage the scenic resources of the National Scenic Area. During this process, the county requested that the applicants tailor their plans to fit into the rules provided by the Scenic Area Development Ordinance. The applicant could have modified the development to reduce visibility and comply with the rules, and I note that today they seem willing to do so, which is certainly a positive sign. If they had done so earlier, the application may very well have been approved. The parcel does qualify for a house if it meets the right conditions. First, I'd like to talk about compatibility. Under the county ordinance, new buildings must be compatible with the general scale, which is the height, dimensions, and overall mass of existing nearby development. That's in section 14.100C of the Land Use Development Ordinance. The planning staff strictly follow the requirements of the ordinance in conducting their analysis here. The dwelling is proposed to be, in our view, 7,134 square feet. The county eliminated half of the daylight basement and reduced it to 5,534 feet. Even if that's the case, even if the county is correct, if planning staff is correct, the proposed size of the dwelling is 70% larger than the next smallest building in the area. 70% larger, and that's a barn. The planning director's decision regarding compatibility should be upheld. The next issue is the visibility of the structure from key viewing areas. Simply put, the decision follows the clear and objective standards found in the county ordinance instead of the subjective analysis provided by the applicant. With our written comments, we submitted an expertly prepared scenic analysis from a former Forest Service landscape architect who was very much involved in the scenic area. That analysis demonstrates and concludes that the proposed house design, siting, and screening would result in a dwelling that does not meet visual standards when viewed from the key viewing areas, even with the proposed window glazing. The applicant proposes a dwelling with 1,231 square feet of glass surfaces, I keep saying that, in a curved configuration, which would result in visible reflections when the house is viewed from the KVAs. The house cannot be approved with the current proposed design, siting, and screening. The decision regarding visibility from KVAs should be upheld. In addition, the applicant requests an after-the-fact review of an unlawfully built structure. Under the ordinance, the unlawfully built structure must be sited on the lot or parcel so that it will have the least impact on nearby or adjoining forest operations. That's in section 3.150 of the Land Use Ordinance. The adjoining forest operators, the Huskies, have have indicated that the siting of the structure within 7.5 feet of the property line will impact their forestry operations due to its proximity to the boundary line. In addition, the 50-foot fire fuel break required by the county ordinance, section 11.120, cannot be met with this unlawfully built structure in the current location. The planning director's decision regarding the siting of the structure should also be upheld. And finally, I again like to note with appreciation that the applicant seems to be willing to negotiate, for lack of a better word, come up with a possibly approvable structure. I would note, though, that that's going to require either a new or an amended application. It really can't be done today. It's got to go through the whole public process route. Thank you very much for the opportunity to comment. Thank you.
Next. Yes, go ahead.
Sorry, Chair. The next on the list is Sheila Dooley.
Just a question for the chair.
Yes, Ross.
Would we have the opportunity to ask questions of those people who are testifying now?
Yes.
Yes.
Do we want to do that later, or should we do it as they talk? I mean, when they're done talking.
Angie, I think the script says to collect testimony and then come back with commissioner questions. Is that correct?
Sorry, Chair, if I may. If it would be more effective and if the commission would like to question each person providing testimony directly after they provide it, that's an option as well.
Okay, thank you. Russ, did you have a question for Gary?
I did, thank you. I was just curious to get your feedback or your reaction to the proposed 33% reduction in glazing, because that is one of the main issues that you've enumerated here. What do you think of that?
First, let me say I'm not the expert in visibility analysis, but I will attempt to answer that question. I believe the staff in their report, as well as today, made it clear that the issue is not that the glazing increases reflectivity. The purpose of the glazing is to mitigate the reflectivity from the glass. If they reduce the glazing, I'm not sure that that reduces the reflectivity in any way, since the point of the reflectivity is to mitigate, the point of the glazing is to mitigate the effect of the reflectivity. So reducing the glazing, I don't think, would reduce any of the reflectivity. However, again, as a caveat, I am not the expert on this, which is why we've hired people when we've needed testimony along those lines. And that's in Mr. Hess's report, which was attached to our comment.
Okay, thank you, Mr. Khan. I had one other question. What's your reaction to the proposal to lower the house?
I think that's a good idea. Oftentimes lowering it reduces the visibility of it, the prominence of it from key viewing areas as well as everywhere else. We need a little time to take a look at it and examine it. It's hard to sort of give you an opinion of whether that's acceptable on the fly.
Thank you very much.
Okay, Sheila,
Yeah, can you hear me? Okay. Can you hear me? Yes. Okay, good. I support the planning director's denial of the application as proposed, and I would recommend or support having the application withdrawn and have them redo their plans. It seems like there's a lot of changes they want to make. As it's currently written, it violates the rules of the National Scenic Area. As has been mentioned, the large unscreened glass face of the house would have major impacts on views in the key KVAs, the National Scenic Area. And also, it would result in high bird kills by birds crashing into the windows due to not being able to tell it's a window. They just fly into whatever, they think they're flying into whatever's reflected in the glass. I don't know if that's a criteria, maybe it's not. And the applicant is just being asked to follow the same rules as everybody else. And I'm concerned, I have friends who've had to change their plans, adjust their plans to conform with rules, the National Scenic Area rules. And I guess I'm concerned that they've already built one building, which they say is an accessory building, but not accessory to anything. So it's actually a dwelling. And they didn't go through the county even to get the siting requirements, which if you're going to do anything, you need to, make sure it's cited correctly. Also, as far as visually screened, in the Jürgen Hess comments, he talks about that the applicant was talking about using oak and pine trees. The oak and pine trees they're referring to are within the fire-wise defensible space requirements of 50 feet for structures on these slopes. And then also oak trees lose their leaves in the winter, which reduces the screening. The pine trees in this type of soils, this poor soils would be difficult to plant pine trees and have them remain alive, according to Jürgen Hess, who's I guess you could read his letter, his comments. I guess I don't need to repeat all of them, but anyway, then the county has concluded that he also says there'd be problems with insect mortality, poor soil issues, and the location of the trees within the 50-foot dispensable space. And the staff report concluded that the pine trees would provide inadequate screening, for visual screening. So I guess that's it. Okay, well, thank you. Thank you for the opportunity to comment. That's it.
Sheila, you didn't do it at the beginning. Can you provide your full name and
Oh,
address?
sorry. Yes, Sheila Dooley, 3300 Venzel Road, Mosier, Oregon. Or you guys should have my address memorized by now.
Thank you.
Next, anybody else want to provide testimony in opposition to the proposal?
We have one more listed in opposition, Jillian Barker.
Jillian? Are you there? If you're on the phone, press *6 to unmute yourself. Okay, at this time, does the appellant want to rebut any of the testimony just provided in opposition?
Yes.
Go ahead.
Just one item. I mean, and it's actually somewhat repetitive, but the attorney for the Friends of the Gorge had a version of the area, and I know staff had their own version of the building area. I just want to repeat that there's definitions that define what building area is in your code, and I believe that we should all use the definitions that are in the code and not rely on subjective different interpretations of how to define area. And by the way, those definitions that are in the Wasco code, I believe, are replicating the definitions that are in the management plan produced by the Gorge Commission. So I believe those definitions were meant to be consistent throughout all the different counties. Thank you.
Thank you. Okay, if there is no further testimony and no request that the record remain open, the public hearing will be closed and the Planning Commission will enter into deliberation. Okay, I want to remind the commission that if the decision is to overturn staff's denial and grant the appeal, the commission will need to specifically identify all of the criteria where staff found the use does not comply and identify specifically why the development meets each of those criteria so that staff can properly amend those findings with the commissioner's decision. Clarifying questions may be made to staff and the applicant. No new information may be added unless the hearing is continued, and a specific request is made to staff to obtain additional information for the Planning Commission's consideration. So at this point, I'd open it up for
Chair?
deliberation. Yes. Vicki? Go ahead. I can't.
Vicki, I think you're on mute. You're on mute, Vicki.
We can't hear you, Vicki. You need to take your Can somebody unmute Vicky?
No, I believe she needs to do it herself.
Okay. There we go. Vicky?
Vicky, try dialing *6 if you're calling in by phone as well.
I think she's on her computer.
Yeah,
Hey,
because you
Vicky.
can see that it's muted. The symbol is up.
Vicky, okay.
Jency, are you able to unmute her?
No, I don't believe so.
We didn't hear any of that, Vicky. You're still on mute.
I unmuted once. Is it?
There you go.
Hi, there you are.
Okay.
All right, Vicky, go
I'll
ahead.
start over. I would recommend that, can anybody hear me?
Yes, we can hear you.
Yes.
Okay, I recommend that we uphold this decision because in the past, we have sent these type of applications back to the applicant to revise it, redo it, whatever. I'm afraid if we start going out the parameters that our guidelines are, we're going to be out of control. And I think it's imperative with something of this size that be brought back to regulation.
Is that a motion or are we just still in discussion here?
If I may, Chair, has the hearing been closed officially? Are you in deliberation or?
We're in deliberation.
Okay.
I wasn't sure if that was a motion is what I was saying.
It was just a discussion.
Okay, all right, thank you. Further discussion, other members?
I have a, go ahead, Russ.
Sure. I mean, I think there's a lot of different elements here, and I do think it's worth talking about it a little bit. It's not like one thing. There's two different buildings. One's already built, many different issues. Potentially issues with the one that's built have to do with the 50-foot setback required for fire. Not 50-foot setback, but 50-foot clearing around the structure required for fire. And the difficulty in doing that if you're 7.5 feet from your property line, the fact that it is outfitted as a dwelling is another issue. And it seems to me the major issues with the proposed house are the size and the amount of glass. So, you know, I think some of those are subjective. It sounds like, and I've listened to staff and they've consulted experts. I've listened to Mark and he's presented a lot of facts and figures. And Gary, you know, certainly has consulted a lot of experts too, as he said. And yet, you know, how reflective is it? It doesn't seem that there is a scientific answer. Mark is, you know, saying it's less reflective. I don't know. I suppose that's a little bit subjective. How much glazing? This is certainly a lot, but I didn't hear that there was a clear number on how much is too much. The daylight basement thing, the overall size of the house is the issue, really. I mean, no matter if you call it a daylight basement or just a basement, is the house too big to be compatible with the immediate neighborhood? A lot of different issues there. So, you know, I'm trying to get my head around which ones are the most important ones and, you know, where there's subjectivity and where there's no wiggle room. So just a comment for discussion.
Okay, thank you, Russ.
The
Leroy?
I have a couple concerns, and I agree with what Russ is saying. There seems to be a little bit on my part as far as how the size of the house is being calculated. Is it, so I'm a little confused in what's going on there. So that's an issue. The glazing, if as he's talking, as the angle of the house turns, your different angles as far as reflection. If it's if it's a ball and you walk around it, the angle of the light changes as the angle changes. So he's got good points in that respects. I also think that the accessory building currently on the property has, as stated, can't be an accessory since there is no building there other than it. Even if there was a house or dwelling there, I would be concerned about how close it is to the property line. The neighbors have certain rights, just like the landowner has certain rights. So yeah, I agree with you, Russ. There's a lot of questions. The other question I have is, if it was there time given for discussion between the planning commission and the applicant, as far as when it was too late, why was it too late? Maybe I'm not understanding the process there.
Brent, can you address
Well,
those?
there is a timeline slide that maybe it would be a good, way to answer that. And certainly a lot of time has went by. I I share the sentiment I hear in your question, Leroy, which is, how did we get here? Did you want to put that slide up to sort of address Leroy's question?
Yeah, Brent, if you want to grab that slide, I can also address that while he's pulling up.
Okay.
Please.
A little bit of history on the timeline there, you'll see in a minute. They did come in for a pre-application discussion in 2018 when we sat down with them with their proposal and gave them all the information they needed. And at that time, it was my impression that we had been clear that they were not allowed to develop roads or anything in that area. A year later, we got notified that there had been a road developed. I believe that original application is just for a dwelling and did not mention accessory structures. I don't remember that map, but again, it was a long time ago. So when they applied again, they applied in, I think it was either July or August of last year of 2019, which we do a 30-day completeness window. Brent sent a letter listing all of the issues that we found in their application, gave them 181 days to have a conversation to work with it. They used the entire 181 days and didn't change anything, came back, and that's when we started getting into our review. And that email is from June, so you can see how much kind of time went by. We had done a lot of work at that point when we had been clear, this is not going to be acceptable, this will be a denial, and then they wanted to make some changes, but the time for that had passed at that point, and that's where we were looking at. Because you can see the July 2nd is when director's decision was issued. So they're looking at coming in after we've done our complete report and already had back and forth for a year. So there was ample discussion coming up to where we are today.
Yeah, I would pretty much sum it up in what Will said, and also the reason why near the end there we sent the email saying, okay, the time has passed for revisions, was because we exhausted so much of the statutorily allowed review time towards this application, trying to get to a point where we could move in a positive direction. But seeing that we weren't moving in a positive direction, we decided that we needed to make a decision on the application due to statutory time requirements.
Brent,
Okay,
can you address the question that was just raised about the methodology for calculation of square footage?
Yes, actually, I would like to note, and I think it was misquoted a couple times, within the criterion, it specifically says visible mass of the structure. So it's any portion of the structure that's above ground. That's why within the methodology provided by the Gorge Commission, provided by the Forest Service. They list garages, covered porch areas, daylight basements, is because those portions of the structure are visible. We didn't take floor area into account. We primarily looked at the portions of the structure that would be visible.
So if I was to understand what you're saying visible surface area?
Any portion of a structure that is visible. So let's say this was a single-story home, and it was sitting on top of the ground. We would just take the square footage of that single story, all of the covered floor area. And also to be clear, to touch on something else, the assessor's office provides our department a comprehensive program that depicts the square footage with illustrations for neighboring properties. So it does take into account, and it does show the square footage and the square footage for garages, covered porches, all of that.
Yeah,
Okay.
to follow up, like a full basement would not be reviewed. We viewed, our opinion was that would be what we called a daylight basement, because you can see that from the front of almost the entire thing would be visible, but maybe a couple feet along the bottom. The orange yellow drawing that he showed was just from one side, where it showed the underground portion. So we counted that. That's the half. That's where we got to 5,000 instead of the friend's 7,000, because we were taking half of that as far as the criteria refers to general scale, height, dimensions, overall mass. So we're looking at those dimensions.
Oh, okay. So I'm still confused because you said visual space.
Visible mass.
I think it's general scale, height, dimensions, overall mass.
Here.
I don't have the criteria right in front of me, but I can
pull it up. 1 second.
While you're pulling that up, it might be helpful to know that this methodology has been employed for at least the last 10 years by the Gorge Commission and the county. We can provide that evidence if the Planning Commission would like to see it. This is not a new methodology for us, and because it can be difficult to compare structures visual mass, given the diversity of designs and aesthetics that are out there. This methodology is an attempt to be prescriptive and objective in applying that rule in an equitable fashion. So it is, although it may seem a little bit like a bit of a square peg in a round hole, this is an attempt to be equitable and fair to all residents who apply for development, because scenic resources are a complex resource to protect and implement those rules consistently.
Okay, so if I could ask, so if I understand what you're saying, if I put a carport or a deck around a house and I don't cover it, it's not considered part of the square footage. But if I cover it, I put an awning over it, it's considered part of the square footage.
Correct, as long as it's connected with the larger structure.
If it's covered.
Yes.
Correct. And this is so this is from the methodology provided by the Gorge Commission. This is where I was citing visible mass. This is where they talk about, calculating the size of buildings by using information from the county assessor's records. The size should include all features that make up the visible mass of a building, and visible mass includes, and they go into detail on what that is.
Thank you. Question for staff. If the applicant wants to continue to now modify their proposal, what is now the process for that? If we uphold the decision of the planning director, then what does the applicant do?
The way that, I guess a quick answer, you have, if they withdrew their application, then they could do the redesign and reapply. However, if they're denied, there is a criteria that says after an application is denied, the applicant cannot apply for the same or similar application for 1 year. And we've been talking about this accessory structure. The accessory structure is a code compliance issue, and that's what we would need to be resolved in that time. So if your question is, what would happen if you going forward and possibly having kind of a design discussion today, we are not able to do kind of a back and forth in a planning commission session. What we're looking at is the application in front of us. We don't have enough time to do kind of a design. I mean, I'm very happy that he's looking at reducing the square footage of continuous and open glass, but again, they were pretty far over that mark. The handbook says 50 square feet, and there is some leeway there, and they were coming in with 1,200 I think square feet. And so we're looking at cutting it down. I would like to sit down with Mark and Tom again and talk about go through the process from the beginning and see where it goes. But at this point, if we deny the application today, that application would be a year from now. If they withdrew, they may be able to do, excuse me, they could do it sooner than that. But
If they withdrew the original application or withdraw the appeal, which are you referring to?
They would need to withdraw the application.
And
which they still could do.
We make a decision.
You would, so Chair, I think, I'm not an attorney, but I think that you would need to provide a continuance of this hearing and allow them an opportunity to withdraw in between now and that upcoming hearing date, future hearing date.
Okay, thank you. Further discussion?
Just to add on to what Will said, basically they would need to make changes that were substantively different enough that the outcome, the impact to the resources was different. And if it was substantively different to that scale, they would need to go back out for public notice.
Yeah.
Back from resource protection agencies.
I was going to make a comment, Lynn, if it's okay.
Sure.
Yeah, I agree with what Will and Angie are saying based on my experience, that we can put conditions on an application and approve it with conditions. But the changes proposed and the changes that might be required to pass this are substantive, and they're not just conditions on the existing application. They're a substantively different application. And so my experience is it would need to go through the process. There's a process where the public can review the new proposal and make comments and so forth. So I don't feel that we could make a motion in this meeting that would say, oh, let's reduce the glazing and lower the house and approve it with those conditions. To me, they're not conditions.
Right.
I would also like to state that from what I'm hearing, Tom and Mark and all of us, geez, this is definitely solvable. I mean, I've heard discussion from the different points of view that have tons of overlap. There seems like a lot of ways to address the issues. If it's the setback, for example, it's not a setback, it's the fire 50-foot clearance. There's a process to request a variance in that, which has not been gone through as part of this application, but it could be. There's the fact that the accessory building appears to be a dwelling, but with removal of some fixtures, that appearance would be mitigated. So, there's just so many ways to win this, but the changes required would require another iteration of this process. So my sense is that's where we end up in this meeting. And that's my 2 cents.
Excuse me. I
Yes.
think you're on track when it comes to that. And whether we deny it with something that says, okay, we're going to deny this, but we're going to eliminate the 1-year wait. You can go ahead and reapply if you so desire.
Yeah, excuse me, Leroy. I think process-wise, we don't have that power. I think the way we would accomplish that is we would make a motion for a continuance, and that would give the applicant time to do just that.
Okay.
Because they would be able to withdraw during that time period, and that would allow them to go through a redesign, another iteration, without having to wait or reapply. Well, they're reapplying, but it's not from scratch.
Yes, Kate.
So do you want to make a motion for a continuance? Or?
Well, my question would be, do we need to state the continue to a certain date, or will Brent?
Yeah, you need to continue to. I'm sorry, what's that, Kate? Yes, you would need to continue to a time and date certain. Location's not an issue. It'll be a Zoom meeting. So we could do it 2 weeks from today. We do have a hearing on November 3rd. Or you could discuss it amongst yourselves where you want to have it, but you do need to have a date and time certain.
Yeah, I'm just looking at the timeline that you already presented. I think it's unrealistic that 2 weeks will be sufficient. I was going to suggest, we normally have a meeting a month out from now, and I think we should allow sufficient time. We've seen the timeline, and it would suggest that it takes some time.
Commissioners, we already have an agenda for the November meeting booked out. And so it would need to be a special date anyways.
This is all hypothetical. Well, it's not hypothetical, but I mean, what would happen during the continuance is hypothetical.
There's also one other consideration is that the length of time we've incurred with this application already to date. There are some self-imposed obligatory statutory requirements on our timeline that we are exceeding and putting ourselves at a little bit of a risk there. It is in the scenic area, and the scenic area has some nuances to their rules that we could push on if we needed to, but we have adopted into our ordinance an attempt to abide by statutory requirements of the state of Oregon. So just a heads up on that one.
Well, let's go with 2 weeks then. I mean, we've seen the material today. If the proposal is unchanged 2 weeks from now, that doesn't take a lot of time. So yeah, 2 weeks.
Is that realistic, staff?
Well, if the proposal were to be changed, we wouldn't be meeting on this proposal. And if it's unchanged, then we would have the benefit of already seeing the material in the comments. So I think it is, I'm second guessing my earlier position. It seems that would be enough time.
So
you've closed the public hearing. Oh, go ahead, Brent.
Yes. Wait, Vicky, I think, is that you?
we might take consideration of the applicant. They have a time constraint also.
I'm concerned about our statutory requirements. There's a clock ticking, and Angie just informed me that we're actually a little past that deadline. And, from what I can gather, we shouldn't be there, and we need to, I'm concerned about that clock. That can be an issue, and we want to address that.
The other thing is that if we were to continue it, it would be for a very specific reason for them to withdraw. We've already closed the public record, and so we can't add any new information at this point. The only design consideration that you could consider at the next meeting would be the one they've added to the record in this presentation. So if you'd like to reopen that to change those circumstances, you could, but after this meeting, technically the record has been closed, and that limits the options available to you moving forward.
And that's why I feel 2 weeks is sufficient. Because they cannot make changes.
I'm sorry. So you're saying they can't, if we continue it for 2 weeks, in 2 weeks, if they come back with a new application, that's not gonna, we can't.
No. So the option available to them is 2 weeks to withdraw. Or to come back and make a decision based on the information you've seen today.
Thank you for that clarification.
A new application would go back to planning.
Okay.
Go through the process.
Oh, okay, I have a question. So where do we stand on the time frame when it comes to legalities? Angie, you brought it up, and Russ has brought it up also. What can we do if we wanted to provide the time for them to withdraw, or is that time already passed and we have to vote on it today?
I think Will is prepared to respond to that.
I don't have the specific date in mind, but if they decide to withdraw, we'd be giving them 2 weeks to make that decision. They could withdraw tomorrow and it would be over, and we would just go, we would go start the pre-app process and start again and go through the application. So I don't know if are you asking what the deadline would, what, I mean, we have.
What I'm trying to do is I'm trying to figure out if we're at the deadline. Do we have to make a decision tonight?
Where are we?
Yes or no?
We're, Leroy, we're past that. We're past the deadline currently. And so we need a decision either needs to be rendered or something needs to occur with it. There was multiple requests throughout the application process for an extension of the application, which is possible. And near the end there, staff was willing to accept an extension, but it was denied. So we're still held to the statutory timelines in ORS as well as the scenic area.
This is Angie. I'm nodding that makes sense to me as planning director.
Are people prepared to vote, or is there further discussion?
Could you restate that, please? Because I missed it.
Could I make a comment, Kate? Sure, thanks. I don't think it's fair to state it as for the purpose of them withdrawing. I think it's to allow them time to withdraw, because it's not our position to influence, but to enable. Thank you. I think that's all we need. Is that sufficiently specific to meet the rules? I think it was Will that was saying that you need.
I mean, that's sufficient to allow them the time needed, and
A continuance needs to be for a specific purpose. I was just
right. I mean, if you went on today and denied them today and sent we did a 12-day appeal period, they would have the option of appealing that, or if it just ended as a denial, they would have to wait 1 year, at least 1 year, according to Chapter 2 of our ordinance, before they could reapply. So by giving them by just doing a continuance for 2 weeks, we're letting them make their decision if they want to withdraw. And not that they need a new application in 2 weeks, because I don't think that's reasonable. But if they want to withdraw, or they can go ahead and wait 2 weeks from now, you can make a decision based on what you've seen.
I like Brad's wording. I think that's sufficient.
Brad, would you like to restate
or make a motion? Yeah. So I would. Kate, I don't think you need to. I don't think you need that second part. I think just what Brad said, because it's part of the process.
And please add a time, 3 p.m.
Kate.
We would hold another meeting, and yes, we would make a decision. Second.
All those in favor, say aye.
You have to do a date and time, please.
Yep, date and time. Correct.
Second, the amended motion.
All those in favor of the motion as amended, say aye.
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 All opposed, say nay. Motion carried. Okay. Staff will have to, I assume, renotice that continued hearing.
No, there's no need for a renotice since you continue to a date and time certain, you don't need to send any more notice out. We did our newspaper notice and all the public notice to get people to this meeting. Now they know date and time, and information's in the same place. We'll be able to get the meeting running at 3 p.m. in 2 weeks.
Okay. And Angie, is this language on the decision of the Planning Commission, is that being held till the continuation hearing then?
Sorry, I'll answer correct. Yeah, you're gonna hold off on that, so skip past that.
Okay, thank you. Okay. I think that's it, unless someone tells me otherwise. Do we have a motion to close? Yes, Angie, is that Angie?
I just want to make sure you weren't ending the meeting. You're ending the hearing?
Yes, I'm asking for a motion to close the hearing.
You're not closing the hearing, you continued it.
I'm continue the hearing. We already did that.
So you're done with that part of
Yeah.
the agenda.
Sorry, I gotta move on to the other scribbles I have here. Okay, so I guess we're ready for director's report.
Just briefly, and I'd like to thank the appellants for joining us this afternoon and everyone else in the audience. Thank you for the participation and the information. That was good for us. So director's report, I'll keep fairly limited given the time. I want to announce a new staff member who I don't see on the call anymore, but he was here for the first half of the hearing. Isaac Stotts has joined us as the new assistant planner for the long range planning program. You'll be seeing a lot more of him as we enter into the ordinance updates this fall and winter. I don't, correct me if I'm wrong, shout out Isaac if you're out there on the phone number, but I don't see your face anymore. Okay, well, I look forward to you all meeting him. He's a great addition to the team. This is week 2, all very new, and he's immersing nicely with the rest of the work that we're doing and the team as well. I also can share with you that next Tuesday is the final Gorge Commission hearing on Gorge 2020. They have one item open for public comment that we've already commented on at other hearings. It largely has to do with agriculture production and farm products, specifically cideries and farm stands. So just a heads up on that one. If you're interested in listening in, you can register for that, but I'm happy to send that information along or just point you to their website. It's always interesting to observe their process. And then also, I mentioned this earlier, but we do have some topics for you for your regular standing November meeting time and date. It will largely be focused on the conclusion of the CAG's work and the community advisory group's work for the 2040 comprehensive plan efforts, and then the beginning of scoping for our Ludo updates, which should be a great conversation. So I'm looking forward to that with you all. Given the time, I hate to keep you with nitty-gritty details on everything else, but if you have any questions, please feel free to reach out or ask them now. You can probably hear my kid running laps around the house with the dog at the moment. It's getting close to dinner time. But if you have anything in particular you'd like an update on today, I'm happy to share with you. Okay, well then I think that concludes my update for you, Chair. Thank you for stepping in for Commissioner Shano this afternoon.
Thank you.
We'll see you in
training.
2 weeks.
Okay, so do I have a motion to adjourn?
I'll motion that we adjourn.
I'll have it. Okay, all in favor, say aye.
Aye.
Okay, meeting adjourned. Thank you, everyone. Appreciate your time. Please. Thank you.
Y'all have a great day.
You too.